Welcome everybody, John Waite here to present to you the 2026 commercial forms changes. I'm going to dive right into it. You can start and follow along with me today if you like by going to the Q&A library on ncrealtors.org. You just hover over the legal and ethics here, and then you can click on Q&As. It'll take you to this page. And if you scroll down a little bit, the summary of the commercial changes are right here. If you want to see past years' forms change summaries, you can actually click on this over here. It's in the categories. You just click this little plus sign here next to forms. It'll take you to the summary of the forms changes. You can see lots of previous years. You can see residential, property management, and commercial. But for today, I'm just going to be going through the 2026 commercial forms changes. And when you click on these links here, then it will take you to these things over here, which are the forms that have the strikeouts and the highlighting and things like that. So let's start with the commission split agreement, form 541. And you can see at the top here just some formatting changes, nothing too crazy until you get down here. And there's a new number 5. Apparently there was some attorney who wanted to get creative and say that, if based on the way the form was drafted before, then maybe a listing firm could, pay a commission split, or say that the closing attorney paid it, and then the listing firm might still be on the hook to pay it. I think personally that's a stretch. Like if you have one of these signed that's on the old form, and the closing attorney has made a payment for you on your behalf, I think it's pretty hard for someone on the other side of that to claim that somehow you haven't fulfilled your contractual duty. But just because it came up, it was something that we didn't want to make sure became a problem, and so the Commercial Forms Committee went ahead and put this in here to make it clear that no, if you are the selling agency under this agreement and you get paid by somebody, then it's fulfilling this duty here. So that's really the biggest change in this one. The rest of these are really just formatting changes to make it a little bit easier to read and follow. By the way, before I get too much further, big thanks to all the Commercial Forms Committee members who volunteered this year. They had a really good cycle, and the changes today, I think, take these forms in a really good direction. Moving on to the exclusive right to sell. Exclusive right to lease and or sell listing agreement. The change in here is also going to be the same in Form 572, the exclusive right to lease agreement, the biggest change in here. And the biggest change in here is down here in the lease commission section. You can see this section before. I can tell you from a hotline perspective, when people call who are not familiar with this section, like let's say they're a new agent, or maybe they're somebody who just does commercial transactions periodically, not all the time. Filling out this section is extremely difficult. It's a dense read. There's a lot of blanks and a lot of things to navigate. So I think the committee did a really, really good job of keeping almost all the functionality of the old section. Not all of it. Some of it was intentionally eliminated because it just was hardly ever used, okay? But you can see here you have a section now that's much, much easier to fill out and a lot easier to figure out, okay, when is the commission earned and due and payable? You got a couple of options there. And then you still have the option where, the commission in Section 7BI, they can be payable on execution of lease or upon a breach of the agreement unless otherwise provided. So you still have that flexibility that was part of the old section. It's a little bit wonky and different from residential, but if you've worked with this form before, then you kind of know how this section works. And of course, if you need any help filling it out, feel free to call the NC Realtors legal hotline. We'll be able to walk you through it. So that's the biggest change for this section here, but like I said, it is also in Form 572. So if you see that change over there, really the same thing applies there. Moving on to the agreement sale for improved real property. Sorry, I'm not as familiar with these titles. Agreement for purchase and sale of improved real property. The residential ones I have memorized a little bit better. I'm getting there. But this is Form 580-T. And we're going to go through this, and the applicable changes that are in this are also in 580L. So I'm not going to do a separate thing for that. But going through 580, you can see escrow agent has now been moved to the first page. Last year, the committee did a pretty good job of cleaning up this whole first section and moving important things more toward the front of the form. That continues with getting escrow agent on the first page. You can see it's eliminated here. And as far as the earnest money goes, you can see now there's been an elimination of the check boxes here. That's because as far as like, yes, it is technically an option where you could share earnest, the interest on any money held in trust from earnest money deposit. You could share that with a client, but otherwise, it's simply not the norm. Ordinarily, it's really only the firm that would end up keeping that anyway in most transactions. Of course, if it's something that you want to negotiate with your client, you still can. But because of the rare use of the second option here, then or the first option, I should say. Really, it's the second option you can see down here that became what's up here. But yeah, this first box is just so rarely used that the committee just felt like it would be easier to eliminate it. Here in the inspection section, I mean, I don't know about how you all feel, but when I see a paragraph like this, my motivation to read it is slim. Dare we say non-existent. And so what the committee did is they broke it out into these subsections and gave the subsections headings to make it much easier to hopefully your client can look at it and figure out what's going on in this section. I mean, and obviously you guys in the commercial context, you have some pretty big differences in here compared to residential. So for example, here, time of day, invasive tests. You can see here normal business hours, reasonable times. You can enter on the property for the purpose of inspecting the property, but you can't do anything too invasive. So that's language is obviously a lot different than the residential, and it's much different. But going down through here, you can see seller. The language is substantially the same as what's up in here, maybe with a couple of changes. But otherwise, as far as what's actually in these sections, it's pretty much the same. Let's see. I'm looking for one particular thing here. Let's see. No, that's not what I'm looking for. Yeah. Yes, here it is. So end date, termination, earnest money, it's in the last section here. Except as provided in 6A, buyers shall have from the contract date to the end of the examination period to perform inspections, examinations, and testing. So for those of you that practice both residential and commercial, this is a really, really big difference between these two forms. It's one of the things where every once in a while I get a hotline call, and I get it from commercial brokers and from residential brokers, where the question is, all right, well, this property has some crossover. It can, maybe part of it is commercial, part of it's residential. Maybe it's just a residential that can be used as a commercial, or it's getting ready to be rezoned because of the area. It looks more like a commercial property. So you have these questions that come up of, all right, well, with these properties that land somewhere in this gray area, then what kind of contract should I use? Or what kind of agency agreement, should I even start with? If we're doing this transaction and we're working with this client. And so there's no one right answer in these scenarios. A lot of times my answer as far as a hotline question would be, well, use whichever one you're more comfortable with. And there's big differences between the 580T, which we have here, and the 2T. For example, this is one of them, where except as provided in 6A, you only have through the examination period to do inspections. That is not true in 2T. You can do inspections all the way till closing, and the seller has to provide reasonable access. So if you got a seller who really doesn't want to do, a lot of different, if they want to really limit the amount of inspections that the buyer is able to do, then, this would be the more appropriate form. Also, if your seller's willing to give more grace, shall we say, for when the buyer can do inspections, then it might make sense to have a due diligence fee instead and use a commercial, the residential contract instead. So those are all things you can kind of think about. But this end date, termination, earnest money, it's something that I get a question about from time to time. It's something I always have to talk about when somebody wants to know which contract to use in order to put a property under contract. And then finally, the commercial committee was very, very focused on making sure that the buyer does not terminate during the examination period. Earnest money deposit will be non-refundable and paid to the seller. So just understand, that breaking that out, putting it in red, that's all intentional to make that a lot more clear so that your clients know it. But as part of tackling that, they really went through and put an emphasis, a stamp on it, if you will. All right. Then down here, we've got a small change, but it's something that could be a big deal depending on what kind of transaction you have going on and what may happen. Here, you have a section that is talking about the risk of loss, right? And so, and as part of that, there's a release in here, and you can see the language is crossed out. That's prior to, it would be it would be on the seller up to the date of closing, and then the buyer after that, right? Well, the date of closing is just a date. That's 24 hours. Depending on what happens, that could be there could be a fight there, and so now there's a specific point in time where instead of just being date of closing, where there could be some overlap there. It's when the deed is recorded, and that's when the burden will shift as far as indemnification goes for anything that is related to a lease that may apply to the property, which is what this section is about. All right, moving on down. Oh, here we go. Yeah, we got language here. The language that's bold here in 10 is just broken out. The language is already there. Like that, this change purely is bolding it and not highlighting it. In the final form, it won't be highlighted. But what I mean by highlighting is just that it's bolded, it's pulled out, it's separated out, is to make it more clear that, in the event of a breach of the agreement by the buyer, the earnest money shall be paid. So it's really, trying to, just like the change earlier in the inspections paragraph, to make it much more clear to a buyer that if they, terminate, then you're going to lose the earnest money, and on the flip side, making it clear to the seller that these are liquidated damages and it's an exclusive remedy. So there's not a lot else you can do with the buyer that ends up breaching or terminating outside of the examination period. And let's see. Yeah. This here, some of you may remember that, I think it was last year or the year before, now I can't remember, but last year, the year before, we tried to insert this and it ended up not being approved in the final copy. And now, this year, it actually was put in. We were able to work it out. But you can see here, much like the residential contract, the parties now have a number of days that they can negotiate. And if they cannot complete settlement, then, just like in the residential side, if they can't complete the closing within the grace period number of days, then the non-delaying party is going to have a right to terminate, in addition to any other remedies they may have. So that's a really good addition, and now you won't need a custom attorney contract to be able to insert that into your contracts, which is usually how I see it done, at least on the old forms. All right, moving on to the agreement to amend. This was really interesting. I would say that if you have transactions going on right now, I know a lot of you move on to the new forms pretty quickly, but this one here is one where really don't use the old form anymore. It was something somebody pointed out, and if you think about section 1 of Form 580, which go over here to go back to Form 580, right? And section 1 is right here, right? And then it goes down. You can see all this stuff all the way through here. And we don't hit section 2 till down here, right? Well, the interesting thing about the way this is phrased, and I can't believe this hasn't been a problem before, is that section 1 is hereby deleted and replaced, is what the old language was. Well, you can see here, all we're really doing is addressing closing. And so I think it's implied that, I'm not sure anybody would actually think that we're deleting, everything in section 1 that I just showed you and just, choosing a closing date. We're going to eliminate the purchase price. We're going to eliminate property description. I don't I don't think it's a reasonable way to interpret how the old language was. So I'm not like, genuinely worried or anything like that. But again, just to make sure that everything's clear. This is just an amendment, has to do with closing. Same thing with the examination period down here. And instead of deleting the entirety of section 1 and then replacing it with a very limited change, it just makes it more clear that we're just amending these particular sections. So in the agreement to amend, you may see you'll see that change, and I would encourage using that form going forward on your transactions. As of the day of this video, you still got 30 days where you can use the old forms. So I would definitely recommend for the 30 days remaining in this, even though I'm sure most of you, if not all of you, have probably already moved on to the new forms. I would use that form there. Moving on to Form 592T, this is the commercial lease agreement for a single tenant. And let's see, where's the change down here? Here we go. Here we've got a change to paragraph 12 to make it clear that when it comes to replacing the lighting, that includes LED lighting. We had at least one tenant who was complaining about that. And I think, if I remember right, wanted the landlord to pay for like an upgrade or something like that. As the property was being upgraded, they wanted the landlord to pay for that upgrade, and the landlord's like, no. Paragraph 12 here says you need to do, the improvements and replacements. So putting that in to make that clear. Then you have some accommodating language for Section 6, and Section 6 is up here, and that talks about utility bills and service contracts. So just making it clear that the things in that section are not overriding what's in here, okay? So Section 6 is really important when you fill it out, because this section here is not going to conflict. If there's a conflict between 12 and what's in 6, then 6 is actually going to control, because it says unless otherwise indicated in Section 6 or elsewhere. So if it's somewhere else in the contract, or that would also accommodate a custom addendum, there you go. This paragraph will be subject to that. And let's see. I think there's one more in here. Yeah. Okay, here we go. In the holding over section, some of you may remember the way that the change is phrased. I think the word double used to be in here. I can't remember now because the strikeout is not there, but in any event, that used to be what was in here. Now you can see it's a percentage instead. So if you want to do double, you would put 200%, or if you wanted to do triple, you could do 300%, and so on and so on. So now it's a negotiable term. So you can, obviously this is a big difference between the residential rental contract, if you're familiar with that. There is no such provision as what's in here, where if if the term ends, then the tenant is simply a holdover tenant where they have no right to be there, and the rent doubles or triples or whatever you guys would negotiate. So that's what a tenant at sufferance means. It means that it can be terminated at any time. So technically you still have a tenancy of sorts if a tenant holds over after their term, but they really have no right to be there. There is no term specified. A tenancy at sufferance can be terminated by the landlord or the tenant at any minute, and that's what that means under the law. Let's see. Yeah, okay, that was it for that one. And then finally, we have the commercial lease agreement for a multi-tenant facility, Form 593-T, and let's see, yes. Here, in the permitted use section, there was some confusion about the language that's currently here compared to, all right, so the landlord, let's say that the landlord has an HOA or something like that, and the HOA has some rules that might conflict with the tenant's permitted use, okay? I think this is becoming a little bit more common, and so what this is meant to do is accommodate those situations where it still puts the burden on the tenant to figure out whether their permitted use is going to be allowed or not, okay? So they're going to specify the permitted use, but as far as figuring out whether that's actually going to be allowed or not, along with county ordinances, regulations, things like that, the landlord will provide a copy of any third-party contract. And mainly that's talking about HOAs, but it could be other things too. Okay, if they have some kind of agreement with someone else that could conflict with this, then they'll provide that as well. In any event, so you have here the tenant still needs to be responsible for figuring out if permitted use is going to be allowed, but the landlord will provide a copy. So that language I think is a little bit more clear than the previous one, which said the landlord was representing that had no contractual obligations to other parties. That was something where it seemed to shift the burden a little bit to the landlord, and the committee felt it was best to keep the burden with the tenant as far as confirming permitted use, but otherwise letting it be something where the landlord would provide what was necessary for the tenant to conduct due diligence. Here, you just have a change. Now you can do a proportionate share for common area maintenance. It's not, probably pretty common that you would actually have that, but every once in a while you will have some facilities and landlords where that's how they operate. So the committee saw it enough where they decided to add that. This language is just meant to accommodate that change as well, so nothing too major there. And then, let's see. I can't remember if there's anything else. Nope. That is it. That's it for Form 593. There's actually one more form that, while I'm here, I'm going to go ahead and show to you. I didn't prep it up, but let me go find it. So if I go back to the Q&As here and go down to the property management forms, there's a new form that is definitely applicable, I think, to you guys. It's the small claims summary judgment forms. Most of you who do commercial, you still end up in small claims court from time to time. I know that because I hear the stories. But yeah, if you need like a guide to help show your landlord of what it might look like to do an ejectment in small claims court, this is a really handy guide to go through that. You have some helpful information on page 2. So it's just kind of a 2-page primer to help people, talk about and look at, all right, what are the basic fundamentals of a small claims case? Now, mind you, you guys in the commercial context, if you're doing commercial property management, yeah, there's a lot of different things that go into that. But if you do end up in small claims court, this might be something where, if your landlord asks you a question about it, know this is standard form 418. It's brand new from the property management section. That may be helpful to you to do that. Let's see. I don't think there's nothing else really in here that would help you too much. I mean, there is a new month-to-month tenancy form in here. It's just a notice of when it goes to month-to-month. Then you could, send this to a residential tenant. But for you guys, as I explained, you are going to have a tenancy at sufferance if somebody overstays the initial term of a standard form lease. So it's going to be pretty different. That is all the forms changes for commercial this cycle. I promise you it seemed short, but there was a lot of debate that went around all those changes. All the changes were very thoughtfully made, and just because it didn't take me as long to explain them doesn't mean that it was somehow a short session. Quite the opposite, actually. Quite the opposite. In the meantime, as always, if you guys have a question about any of the forms, you can call the NC Realtors legal hotline, and we will help you through it. Otherwise, thanks for tuning in, and hope you guys have a great rest of your summer.